a 25-year-old store clerk at Sabrine's Supermarket on December 22nd, 2002. Despite there being no physical or ballistics evidence linking him to the crime, he was wrongfully convicted and sentenced to life. In January 2025, it marked 22 years that he became a suspect in the murder, and in March, it will have been 22 years that he's been in custody for a crime that he did not commit. Question that I'm going to ask him is, how does he wrap his mind around that, being innocent, and how does he stay focused and positive? So I'm going to go ahead and jump into some of the details of the terrible injustice that has kept him locked away in a cage, away from his freedom, from his family, from other loved ones, as well as community that greatly deserve his presence. The petition was filed yesterday at around 10:30 a.m. Central Time. This petition is challenging Kathy Keena, the Dakota County prosecutor at the time in 2003. It's challenging Kathy Keena's office to address why justice was not served when corruption surfaced just a few short years after Mr. Vance's conviction. And I'll get into that, how that occurred. Instead of acknowledging her mistake and agreeing to reevaluate the case sooner, she has persistently defended her actions of her prosecutorial misconduct with her emotional appeals during closing arguments at Mr. Vance's original trial to influence the jury towards the conviction. The petition presents extensive evidence suggesting that Mr. Vance was unfairly targeted by the police, by their misconduct, and also them withholding evidence. Witnesses were allegedly offered incentives for their testimonies, many of which have since recanted. Police strategically used jailhouse informants against Mr. Vance and coached them on how lying could benefit them in their own life. Some witnesses were reportedly paid significant sums. We have located traceable bribes that exceed $2,000, but there are more untraceable due to illegally destroyed records by the Metro Gang Strike Force, which I'll refer to as MGSF moving forward. Kathy Keena admitted on recording to paying for their testimonies that led to Mr. Vance's conviction in front of the judge. An anonymous source also recently informed Unicorn Riot about knowing the real killer in Mr. Vance's case. One alleged accomplice is already serving 2 life sentences for a different murder, while another one remains free from prosecution for the Sabrine's robbery and murder. At this point, I'm curious where investigators are at on this new information, and that's something that we will be working to follow up on to see, have they read the article? Are they interested in digging back into the case? There is some questionable things on the original investigation, and there was somebody that was interviewed that was never followed up on that raises that question. So I have a question here to ask him. It would be, despite filing appeals all the way up to the Minnesota Supreme Court and submitting post-conviction relief petitions aimed at retrieving his phone records, proving his alibi, using cell phone towers during the murder time frame, but all those attempts have been denied. And I want to confirm that with him when he gets on the line, but that's my understanding. So now into the actual verbiage and details of the actual petition. The petition begins with, Mr. Vance is confined under this judgment, convicted on October 5th, 2004 of multiple charges, including first-degree premeditated murder, first-degree felony murder during an aggravated robbery, and second-degree intentional murder, sentenced October 8th, 2004. The petition includes affidavits demonstrating potential jury reconsideration. There are multiple affidavits from key individuals asserting coerced testimonies. Key witness statements indicate manipulated narratives that impacted trial outcomes significantly. Present affidavits are included multiple affidavits from Maynard Cross, signed in 06, 2021, and 2024. Affidavit from Regina Hagerman, signed in 2021. Affidavit from co-defendant Dominic Johnson, signed in 2021. Melissa Seitz affidavit, signed in 2021. Affidavit from Darlene Walton, signed in 2023. Affidavit from Kentrell Anthony, signed in 2022. Affidavit of Dante Reese, signed in 2007. affidavit of Edward Townsend, signed in 2007, affidavit of John Martin, signed in 2007, Michael E. White affidavit, signed in 2005, affidavit for Wayne Jones, signed in 2007, affidavit for Trevor Crawford, submitted in support of 2007 post-conviction petition. These affidavits collectively provide the court with grounds to determine that the jury might have reached a different verdict had they known the truth. Additionally, with multiple affidavits meeting the criteria for recanted testimony of the law, this alone deems Mr. Vance's indictment insufficient. Additionally, the following details about the Metro Gang Strike Force, which, like I said, I'm going to refer to as MGSF. This provides context supporting withheld or destroyed evidence claims, among many other violations in Mr. Vance's case. The petition goes on to explain that in 2009, the MGSF was disbanded by the FBI following revelations of deeply disturbing conduct by its members. A report titled, quote, Report of the Metro Gang Strike Force Review Panel in August 20, 2009, highlighted that the MGSF lost substantial evidence that should have remained in the evidence room and routinely mismanaged or misappropriated evidence connected to criminal prosecutions. The report also reveals that officers frequently violated constitutional rights by performing unauthorized searches and seizures without valid justification. They also contaminated legitimate searches by seizing unrelated money and personal items for their own personal gain. There was also assault, sexual, physical, they terrorized the community. The report further noted misuse of the NCIC database for non-governmental purposes by at least one employee. In late 2008, officers were asked to sign blank forms for evidence destruction, but these forms were used to falsely note destroyed evidence in cases where it was not destroyed. That's where they located that these items were being used for personal gain. Additionally, a relative of a strike force employee had regular access to seized property at their offices. A relative identified as Miss Colleen McManus, sister of Officer John McManus, also relative to Judge McManus, all three related to Philip Vance's case. Both Colleen McManus and Officer John McManus were part of his investigation and also testified at trial. The MGSF report also reveals document shredding related to numerous cases and attempts to delete files concerning confidential informants following a legislative auditor's report suggesting misconduct. Case files reviewed were often deficient in crucial information about searches, informant involvement, evidence tracking, case status, and communication with prosecutors. I know this is really probably very boring, but I needed to say all that to get to this. This context is very critical for Mr. Vance's case, as there are compelling reasons to suspect that the MGSF officers withheld critical Brady, Giglio, and Youngblood evidence from both defense teams and Dakota County prosecutors. This suspicion is particularly strong regarding recorded interviews with informants like Maynard Cross, who we have 3 affidavits from confirming he stated under oath that he informed investigators during a recorded interview he knew nothing about Sabrine's robbery or Mr. Vance and wanted no involvement. Yet this recording was never made available despite extensive searches through archived police files. It was used in their exhibits as evidence, but never located. Furthermore, there was a wire supposedly worn by witness Melissa Stites, who we also have an affidavit for, and this was said to be capturing incriminating statements, but the recording was reportedly unusable or deemed inadmissible as an exhibit during trial proceedings and also was never located in evidence. Recently discovered documents in South St. Paul Police Department archives now reveal exculpatory, at minimum, potentially exculpatory evidence previously undisclosed. Collectively, the MGSF report, alongside witness affidavits and recantations, demonstrate that Mr. Vance did not receive a fair trial due to due process violations stemming from coercive tactics employed by investigators acting unlawfully and in bad faith, on one second. Okay. Okay. I'm going to start that sentence over. Mr. Vance did not receive a fair trial due to due process violations stemming from coercive tactics employed by investigators acting unlawfully and in bad faith. This resulted in nearly 22 years of unjust imprisonment for Mr. Vance based on compromised investigations leveraging false testimony. The evidence of Mr. Vance's innocence and wrongful conviction is substantial and justifies granting him an evidentiary hearing. And that's what we're asking for in the petition. That's eventually what will, if the judge sees everything and doesn't immediately say, we need to vacate this, then we will be, requesting the evidentiary hearing. The significance of this petition being filed at this moment is there's several reasons. Mr. Vance's conviction is defective because it relied upon false evidence provided by Melissa Stites, who provided inculpatory evidence against Mr. Vance. Through her affidavit, Ms. Stites explained that she was pressured by members of the Metro Gang Strike Force to falsely accuse Mr. Vance of murder and to assist in the prosecution of Mr. Vance through the provision of false testimony and statements. Mrs. Stites' affidavit also explains that she was explicitly instructed by police officers to give false testimony in Mr. Vance's case and at his trial. Stites has recanted her trial testimony and stated that she never heard Mr. Vance make any statement indicating that he played any role in the killing of Khaled al-Bakri. 2, Mr. Vance's conviction is defective because it relied upon false evidence provided by Regina Hagerman, who testified before the grand jury in Mr. Vance's case about threats that Mr. Vance was claimed to have made against Hagerman's then fiancé to obtain a lawful basis to search the cell of Mr. Vance's co-defendant, Dominic Johnson, which resulted in the obtainment of a letter used at Mr. Vance's trial, which made it falsely appear as if Mr. Vance was trying to witness tamper. Hagerman has recanted her trial testimony and stated that she has no knowledge of any fact that indicates Mr. Vance played any role in the killing of Khaled al-Bakri. 3, Mr. Vance's conviction is defective because it relied upon false evidence provided by Maynard Cross, who provided inculpatory evidence against Mr. Vance. Through his affidavit, Cross has made clear that, contrary to his testimony, he was not at the Buttery on December 2nd, 2002, but was instead in Milwaukee, Wisconsin. Cross's affidavit also clarifies that the details he provided about the circumstances of the murder, which he claimed to have learned from Mr. Vance, originated from conversations with members of the Metro Gang Task Force, officers who wanted Cross to incriminate Mr. Vance. Cross has recanted his testimony and stated that he has no knowledge of any fact that indicates Mr. Vance played a role in the killing of Khaled al-Bakri. 4, Mr. Vance's conviction is defective because the indictment is defective, since the indictment relied on false and inculpatory grand jury testimony provided by Maynard Cross, Regina Hagerman, and Jacqueline Ezell. 5, Mr. Vance's conviction is defective because it relied upon false evidence provided by Dante Reese, who provided inculpatory evidence against Mr. Vance. Through his affidavit, Reese explains that he was promised leniency in his own criminal matter by investigators in Mr. Vance's case if Reese would provide any information about Mr. Vance's case. Reese has recanted his trial testimony and stated he never heard Mr. Vance make any statement indicating that he played any role in the killing of Khaled al-Bakri. 6, Mr. Vance's conviction is defective because it relied upon false evidence provided by Trevor A. Crawford, who provided inculpatory evidence against Mr. Vance. Through his affidavit, Mr. Crawford explains that Mr. Vance never made such a confession and that Mr. Crawford only testified to this effect because investigators threatened to involve Crawford's older brother in the case. Crawford has recanted his trial testimony and stated he never heard Mr. Vance make any statement indicating that he played any role in the killing of Khaled al-Bakri. Mr. Vance's conviction is defective because the state failed to disclose Brady, Giglio, and Youngblood evidence in criminal discovery. For purposes of the Youngblood analysis, it is alleged that the state acted in bad faith when it failed to make these disclosures. 8, Mr. Vance's conviction is defective because he was prevented from presenting an alibi defense despite having alibi witnesses available to testify. Specifically, Darlene Walton has provided an affidavit testifying under penalty of perjury that she was with Mr. Vance at the time of the murder and that neither of them were at the scene of the murder on December 22nd, 2002. Mr. Vance was unable to present his alibi witness through a combination of witness tampering by police and ineffective assistance of trial counsel. Number 9, Mr. Vance was denied his 6th and 14th Amendment right to effective assistance of trial counsel and appellate counsel. Mr. Vance's trial counsel's representation fell below the standard of reasonableness and prejudicially affected the outcome of the proceedings. Number 10, Mr. Vance was denied his 6th and 14th Amendment right to effective assistance of trial counsel when trial counsel unreasonably failed. Hold on. What happened? Hold on, I think I lost you guys for a second. Somebody give me a thumbs up if you can hear me.
We can hear you.
Yeah. Okay. Mr. Vance was denied his 6th and 14th Amendment right to effective assistance of trial counsel when trial counsel unreasonably failed to present alternative perpetrator evidence at trial relating to Michael Smith and or Lorenzo Eide, and when trial counsel unreasonably failed to investigate, develop, or call alibi witnesses. Mr. Vance, this is the last one of these long statements. Number 11, Mr. Vance was denied his 6th and 14th Amendment right to effective assistance of counsel when counsel unreasonably failed to argue that trial counsel's failure to investigate or present alibi witnesses or to present alternative perpetrator evidence at trial relating to Michael Smith and or Lorenzo Eide constituted ineffective assistance of trial counsel, making no reference whatsoever to ineffective assistance of counsel, but noting repeatedly the unusual decisions of trial counsel, such as not introducing an alt-perp evidence. Okay, that takes us to the request on the petition, what Mr. Vance respectfully requests following the relief of this court hearing. He's asking, 1, that the court accept and consider the brief accompanying this petition. 2, he's asking that an order be issued for an evidentiary hearing wherein proof of the allegations herein can be offered. 3, that an order be issued directing respondent through its counsel at the Dakota County Attorney's Office to produce petitioner at all hearings held by this court. 3, that after a hearing on the merits, an order be issued directing that Philip's conviction for first-degree premeditated murder be vacated and set aside. 5, that after Philip's conviction for first-degree premeditated murder is vacated and set aside, an order be issued directing that the jury verdict for first-degree felony murder and second-degree felony murder be vacated and set aside. And 6, for such other and further relief as law and justice may require as determined by his court, or by this court. In closing, this petition is grounded in the Minnesota and United States Constitution, the Minnesota Rules of Criminal Procedure, relevant case law, and the pursuit of justice. It is supported by a comprehensive 74-page memorandum and an accompanying 6-page exhibit list, which offers a thorough analysis and presents compelling evidence to support Philip's claim of innocence. So the next step in the legal proceedings, we are anticipating a response from the state, which is Kathy Keena's office in Dakota County, within the next few months. That can look like 60 days. They can extend it another 60 days. So that's why we're saying the next few months. We really don't know how they're going to respond or when they're going to respond. But a judge can eventually, make an order for them to respond, and then we just have to wait. Additionally, we anticipate the Minnesota Conviction Review Unit, which is the CRU, will either finalize their review or withdraw Philip's application, as his file has been pending for over 3 years with their office with no movement. I was hoping Philip would call in, but I have not received a call from him, so we're going to, just going to continue to close out, and then I'll open up Q&A, and maybe he'll hop on at some point. But our call to action for this, for everybody, that can, outside of media, to join us in supporting Philip Vance as his legal team works to demonstrate his innocence in the court in court in the coming months. Supporting will look different ways, and so you'll just have to keep an eye on his website to see what actions may be or what's needed, because every voice is crucial in amplifying his story and advocating for his justice. You can share right away. You can help by sharing his story with the hashtag Free Philip Vance, and it's PhilipVance. It's just one L in Philip. You can also contribute to his legal fund to finalize the expenses for the legal fees via the GoFundMe link, and that is also on the bio on his page. It's GoFundMe, www.gofundme.com/f/please-support-Philip-Vance. So if you can't find it, hopefully you can go back to your notes if you're taking notes. You can also participate in events organized by the Free Philip Vance campaign team. And there's several of us, so you can just keep an eye on Philip's Facebook page or his website for that. Your support can absolutely make a significant impact in ensuring a fair outcome. And so again, visit www.freephilipvance.com to learn more and get involved. I'm going to open it up to media. You guys can unmute, and any questions you have on anything I read. I know it was a lot of information, but I'm happy to go back if you had any questions that stood out.
I have a question for you.
And if media doesn't jump in, I'll open it for public questions. Oh, are you unmuted, Rebecca?
I think so.
See, I think I have to go unmute you guys. Hold on. I was trying this earlier. Okay, can you say something now?
Can you hear me now?
Oh, I don't hear you. I don't know if it's on my end.
Yeah, I'm unmuted on my end.
It's
I
on
have
your
everybody
end, Nikki, because we can hear Rebecca.
Say something now.
Is it unmuted now?
Maybe you'll have to put your question in the chat. I'm not on my side. Everybody's unmuted, like on my control, so I'm not sure. David, can you unmute and say something? See if
It's definitely you. Everyone can hear except
Oh,
you.
I just can't hear anybody. Okay.
Yeah.
I can't hear the question, so you're going to have to put something in chat. You can talk if everybody else can hear you, but if you could put your question in chat, because I'm not hearing anybody. Oh, hold on. I'm going to try something really super quick. I think I got it. Now, I'll say something.
Okay, now can you hear me?
Yes, I can hear you now.
Yay! Okay, my question is, did I understand this correctly, that he was charged with more than one murder?
No, it's only one. Sorry about that. My gosh.
Because there was a premeditated murder, and then there was like a second
Only one murder.
So let me, Rebecca, there's
Charged.
normally,
Go ahead, David.
normally when any crime happens, prosecutors put a lot of charges on there, and that's normally for plea bargaining and stuff like that. So there's one incident, they just charged him with a different, trying to meet different criteria, as if one was premeditated and one was first degree murder.
And he was found guilty of both of those charges?
It's one trial, yes.
It's one trial, and they put all of them on him to gain the life conviction, yes.
Okay, so explain to me how that's legal.
The attorney's not here, like I can't get into how they do it, but they always trump up charges, and that's
like, it doesn't make any sense to me. If it's one body, it should be you charge at the highest charge and then let the jury work on finding what they think he's guilty of, even if it's a lesser charge.
Yeah, I mean, they always trump up charges, so that would be something that we would have to see how that goes with trial. But I mean, all three of those stuck on his conviction.
Did they ever get the person who actually committed the murder?
No, we just within the last 2 weeks, an anonymous tip was given to a media called Unicorn Riot that there is the name of the actual perp out there. So that's what I said. We're waiting to see if investigators are going to pick that up, if they're going to look, we don't know. Right now, our team's focus, Philip's focus is his post-conviction relief. And what investigators do with that information is something outside of that. But right now, it's just to prove that he didn't do it.
So he's still at the state level then?
Yeah.
Okay.
Um,
Okay. I have a question in the chat from Karen. All informants, witnesses have recanted their testimony. Has Philip experienced any retaliation from inside while incarcerated at Rush City, specifically as these press conferences? I can't answer that because I don't know. I mean, he hasn't said anything, but I can't speak for him on that. But as far as the recantations, we have 11 recantations. So I think maybe only 2 haven't recanted, but not because they didn't want to. Maybe they weren't located. So I would have to get confirmation from the legal team, but we have 11 recantations.
Nikki, I'll just say real quick.
Yeah.
Can you hear me now, Nikki?
Yeah, I can hear you.
Also, too, just looking at one of there was 41 petitions filed yesterday, and one of them just looking at a witness talking about that he knew. And I'm just saying this. I'm not asking a question. I'm just saying this from an education standpoint. That a witness is saying that he knew nothing about the case, and the only thing he knew about the case is what the officers kept telling him while they were trying to get him, trying to teach him how to testify against Philip. And that witness also says that there should be recorded tapes of that. I know. Interesting enough, I learned about something called the Scales decision.
You're talking about Maynard Cross?
No, maybe so. But I know from the Scales decision that anytime and every time a police officer is taking testimony, they are required by Scales law to record that testimony.
This is something that's in the petition, David.
What's in the petition is a witness saying that they were coached, that they knew nothing about the case except for what they were coached to testify. They learned, I think they learned about the case, they learned from the police officers, not from Philip Vance, that they never met Philip Vance.
Right.
And they're also saying that was recorded. What I'm saying is I know from the Minnesota versus Scales decision that it's mandatory that police record all interrogations, especially during the time when this interview took place. And I know that because of my own criminal legal case with Metro Strike Gang Force members that we won based partly in the police lying about stuff during the so-called interview when they didn't have any recorded interview. So it just kind of blows me that it's in there. It's going to be really interesting to see how. Well,
that's part of the petition of Brady and Giglio violations where MGSF withheld that information because in the original trial, there's an exhibit stating that there's a recording from Maynard Cross stating what you said. And he clearly states in his affidavit, they recorded me. And in the original trial, they put it in an exhibit that it was evidence. And we've never been able to locate that evidence. And so that is one of the claims on the petition, that this evidence is said to have existed and helped with the conviction in the original trial, but the evidence doesn't exist.
I'm saying the judge was supposed to instruct the jury. The judge was required to instruct the jury that the evidence of the officers did not have an enhanced credibility. Matter of fact, they had their credibility goes downward because they're talking about so-called evidence when they didn't record according to Scales. That's
right, exactly. And there's a second one, the interview of Melissa Stites, that was done, that they ended up saying at trial that it was they were unable to use it, but yet they used it to convict him by hearsay. Like, oh, well, this is what she said. And it was able to help with his conviction without the recording. So there's a lot of violations, which we knew existed, but now finally actually having it on paper and going through every box possible and not locating that just gives that leverage that his indictment is invalid. Like, he should never have been indicted to start with. David Weiss saying, what does it mean to say that some of these affidavits meet the criteria for recantation? So they have to meet certain lawful and legal criteria as far as like credibility. David, do you have any specifics on valid recantations? What they say they meet the criteria? So it's generally that they have to meet the legal criteria of testimony, be under oath, be credible, and you just can't come and say, oh yeah, I'm going to change my mind on that. Like, they have to still investigate it and like secure the validity to it. So that's what it means, David, that they actually investigated. Well, the attorneys now have actually looked at it and seen that the recantations are valid, and they've been reviewed and balanced against truth and, everything, facts of the law. Anything else? I'm going to put my, Karen says, what is Governor Walz's stance on this? Doesn't he have the power to exonerate Philip? Governor Walz has been silent. Philip wrote to him about 2 weeks ago. I think he's written to him before that. We did a petition, I think, that we sent to them. We don't have, he's silent on it. And so he does have the ability to inspire the prosecutor to reinvestigate. When we've gone to Kathy Kena, when the legal team has gone to Kathy Kena and asked for statements or whatnot, even we did an action at her office in November of 2023, and she put out a statement that she was cooperating with the CRU. The CRU is a conviction review unit in Minnesota that has had Philip's application since 2021, and they've commuted one person, vacated one person's sentence, and exonerated one person since 2021. Philip was one of the first applications they received, and they've not done any. They said they've done investigating, so I'm not saying they haven't done anything, but they haven't come back with a response. But yet every file that they've handled that didn't meet the criteria of showing innocence, they've gone back to the person and say, we don't locate any evidence of innocence in this case. We can't help you. They haven't done that with him either. So they haven't said we can't help you, and they haven't completed their review. In March of 2024, they had a final exit interview with him, and it's now about to be March 2025, and he hasn't heard a single word from them since March 2024. There's some other questions. Hold on. Let me help her in the chat. Explain the difference between him getting the conviction overturned and a governor's pardon. Okay. And you said just like ineffective assistance of counsel has to meet certain criteria for the court to recognize it. Yes, correct. Okay, so explain the difference between him getting a conviction overturned and a governor's pardon. A pardon just means like they're going to deem that you've served time. You've successfully served the time. You've been a good citizen in prison. We're going to let you out, and they either like allow you to finish your sentence on probation or parole, or they just completely let you come out like you're clean. You're free of paper, free of check-ins. To have it overturned is to actually have your name restored, to actually publicly state that you did not commit this crime, that you were innocent and you were wrongly convicted. So it's very different. It should be known that he could have taken a plea in the beginning. And he said, I will never take a plea. I will never admit to a crime I didn't commit. So he's actually served nearly 22 years because he says, I will never say that I did this. And so ultimately he wants to walk out the doors with his name free and clear. And that's the hope. That's the goal. There's another question. Tell us more about the evidence they found at St. Paul Police Department just last year. Why don't you talk about that, Denise?
Actually, I really didn't remember from our conversation, and I wanted you to tell me more about it again.
Last year.
Remember they went with the lawyers into the St. Paul Police Department, and they found a bunch of files that were new information, and that's one of the reasons that we can bring this new evidence forward.
Well, that's what this is, saying that there was evidence that was used to convict, but the evidence doesn't exist. That's the new evidence.
Okay,
yeah.
Thank you.
Yep. Because that was what took so long, because when the attorney was asking for the files, and he kept saying, well, we're missing something. We're missing something. We're missing something. And ultimately they were like, what you're asking for doesn't exist. So we were never missing anything. They lied. They either lied or they destroyed the evidence because the evidence didn't work in prosecution's favor.
I see. Thank you. That helps.
Yeah, those recordings were never played at the trial. They were never used at the trial. They were just taken. The court and the jury just took their word for it that it showed his guilt. So nobody's ever heard those tapes.
Thank you. That really clarifies it. Appreciate it.
Yeah, for sure. Anybody else? Okay. So how do we hold these people accountable for destroying Philip's life? That is a great question because these people are in power, in such high power, and they work so closely together. Even when we think like, oh, we have Keith Ellison's office and he's supposed to oversee this conviction review unit and he's supposed to make sure everything's done fair. Well, you work with these systems. You work with the prosecutors. You work with the lawyers. You work with the district attorney. You work with all these people and you have working relationships with them. And it's, you scratch my back, I'll scratch your back. And not to get into too much, but Keith Ellison, when he was first elected in Minnesota office, he was in trouble with the law. And actually, the Hennepin County attorney at the time helped him get out from under that. So therefore, then they had a different type of relationship where they wouldn't step on each other's toes. And so then Ellison wouldn't really investigate a lot of the cases that Freeman handled. It's just that makeup of this working relationship, this respect they have for each other. I mean, at the end of the day, their offices all have a piece of the puzzle of convictions, exonerations, everything. So to exonerate Philip, they are all going to have to admit wrongdoing. And they're not going to want to do that. And I think that's been the worst struggle is because Kathy Keena, she was in office only a year and a half when she secured this conviction. She was the first woman elected into Dakota County in her position. So therefore, she was motivated to be the hero of her community. So now, 22 years later, she's the head of that office and the only woman that's ever held that role. So you're saying that we're asking her to say she made a mistake, that really she built 21 years of her career, stacking on that. So is she going to want to say that she made a mistake in her first year and a half? Absolutely not. Because then if she says she made a mistake, then other people have to say they made a mistake. And then, it just turns into a mess. And that's why we're where we're at. And that's why a lot of people don't speak up. And one thing about this is Philip has always been very open and adamant that he is innocent. And, people in power don't like people that are confident when they believe that you're beneath them. And I think that has a lot to do with it. Does anybody else want to contribute anything? Or hold on, I think we have some more questions. The recording not actually being played at trial, but officers saying they heard it. Question. Okay, so Sandra, the recording not actually being played at trial, but officers saying they heard it is what I questioned about the trial in 2004. Exactly. Because at that point, how can a judge rule on something that's deemed hearsay? Because I didn't hear it. You're just telling me you heard it. Now that's hearsay. You can't even get somebody arrested on hearsay. So it's just very, very quite interesting that they actually gained a whole conviction on that hearsay. I think I have one more question up here. So just to finalize your question, Rebecca, how do we hold them accountable? Just know that all this is documented very clearly every step of the way. And a lot of this is once Philip is free, he can combat when he's out. He can go after what he deems justice for himself. Like we can all say what we think that should look like, but really it's going to be up to him what he feels justice looks like, because who knows, he may just be happy and just want peace. All of us will be like, no, you need to go after, we just have to let him decide what justice looks like for him. Let's see. It's not about innocence or guilt from the prosecutor's point of view. It's about conviction rate to get reelected. Exactly. And that's exactly what it is. Now, I want everybody to understand that there's a 13% error rate that is allowed in prosecution. Minnesota is at 13.4% error rate. So they're above the average error rate in prosecution. And that's what blows me away, that that's not being investigated. Another thing that we want Kathy Keener to answer to, in 2009, the Metro Gang Strike Force was disbanded. The meeting, I'm about to close. This is the last thing I want to say if nobody else has any questions. The Metro Gang Strike Force was disbanded in 2009. Every single case that they handled at that time should have been open for review. In Atlanta, all state cases, same situation. They had a strike force in Atlanta in like 2010, 2013, I think, somewhere in that timeline. Same thing occurred. They reopened 300 cases that those officers had touched. Minnesota should have done the same thing. Kathy Keenan, every prosecutor should have said, hey, these cases that those officers on, I want my record to look good, but I want to make sure that we really have guilty people for these crimes. That's what should happen. That's the pressure we want on Kathy Keenan. There's one more question. Can you speak to the argument of structural error made in the memorandum? This strikes me as the most damning piece of it all. I did not go over that with the attorney, and I'm not going to try that. It is something that eventually I can get the attorney. He wasn't available today. He had other commitments. I was hoping, and I was also hoping Philip would be able to hop on, but looks like he wasn't able to. So we, I think there's going to still be a lot of questions as we're moving through this court process. There's a lot in that petition, and I hope that we can maybe even do another one of these as we go to answer more questions if people deem it's necessary, if Philip deems it's necessary. So, but if there's no more questions, then I will probably go ahead and close out. Just give you guys one more second if you have any more questions. I'm sorry that we weren't able to get Philip on. I was really hoping because he had most of these bullet points were going to be him, but
all right, fam. How we doing? So we jumped in on Nicole's. She froze up there. But the young lady that was speaking was speaking there. I basically wanted to give her the floor on this her whole thing. For those who don't understand what's going on, a young man named Philip Vance, who was wrongly convicted of a murder. Kathy Keenan was a prosecutor just like Amy Klobuchar, right? So Amy Klobuchar built her career off of locking up black men. And that's the bottom line when it comes to Amy Klobuchar. That's why she's where she's at today, because of the black men that she locked up. Right? That's no ifs, ands, or buts. Two of the black men that she locked up were able to be freed. Because of the lies that were told and the railroading that was done to get people to put a finger on these two young men. But Myron Burrell was one of them, and Melvin Haynes was another one of Klobuchar's victims. Now we have this other lady who basically was doing the same thing to get her name out there. They was looking at cases, finding cases of young black men that they could put in jail and blow up their whole rise up to the top. And if we can sit here all day if you want, and Rev, it's this and this and that. No, this is what it was, people. You gotta, sometimes we gotta come down and start really, really looking at certain things that has happened. The police department. Now, one of the things she talked about on here, and I want to talk about it too, was the Metro Gang Strike Force. One of the most ruthless, corrupt group of police officers on the face of the earth, especially in Minnesota. And a lot of people don't know about this. See, here is where I get upset at the Republican Party, because the Republican Party never looks at anything when they start talking about writing bills for police officers and things that sort, right? And then you have I get upset at the Democratic Party, because those two are fighting each other, right? The Democratic Party knows what goes on. They know about these gang strike forces. The Republican Party have no clue. Only thing they can think about is, let's give the police more power to do whatever they want, when they want, how they want, and we're going to back them no matter what they do. The Republican Party here in Minnesota fought so hard for the SROs in the schools, to give the SROs the ability to fold kids up into pretzels. That's what they died on that hill. But this gang force was so bad, the FBI had to come in and disband this unit. This is how bad these people were, because they was railroading young black men. So the Democrats tried to step in and start going, well, you know what? We don't need to put kids in prisons, and we don't need to do this here, which they went too far this way, where the Republicans went too far this way. No one ever wants to meet. They never want to meet in the middle. They never want to hear what the public has to say. Let's meet in the middle. We don't have to go to the point to where the Republicans are saying, let's lock them up. Have that Richard Nixon mentality. Let's lock them up and throw away the key. Law and order, right? Stop and frisk, all of that stuff they want. And then you got the Democrats on this side saying, well, no, we can't lock people up because look at all the exonerations that's going on. I mean, black men have been getting out of prison like crazy because of the tactics of the police department. That brings me to this here task force. This task force, again, like I said before, was so bad, was so mean, so corrupt, that the FBI had to come in 2009 and say, no more. We can't let you guys do what you're doing here. And they disbanded it. And people like Kathy Keenum couldn't get her career off the way she wanted to. She couldn't be an Amy Klobuchar. By the time Amy Klobuchar was doing what she's doing in Washington, her career had went boof. And then Amy Klobuchar decided to come and start bragging on her conviction of Myron Burrell. If y'all remember this, Amy Klobuchar decided to run for president. Think back when this happened. We met Amy Klobuchar in St. Louis Park, at the school there in St. Louis Park, and would not let Amy Klobuchar come on stage at her own rally. That's what we did. You were not allowed. You're not coming out of it. And they canceled the rally because we got the stage. We stood on that stage, and we made sure Amy Klobuchar knew her time was up when it comes to Myron Burrell. We know who you are, Amy. And Amy did not come out of her little dressing room or wherever they had her hidden on her bus in St. Louis Park. Some of y'all probably didn't know that. Some of you probably remembered it. But look it up. Look it up. We took that stage, did not get off of that stage because Amy Klobuchar was not willing to come out of there and said she made a mistake, said she was wrong and railroading those two black boys at 16 years old, and they stuck them in an adult prison. That happened. This is the same thing with Kathy Keenum. Kathy Keenum will not come off her perch and say Philip Vance is not the one who murdered those people. That man needs to be freed. And the problem is we don't have enough people to get behind these convictions that are wrong. When we cry justice, we want justice. This is what we're talking about. Philip Vance is what we're talking about when we cry justice. When people are running around, you got justice. No, we don't have justice because we got too many black kids that are being railroaded, being thrown into prison. This is what we're talking about. For anybody who follows me, y'all know one of the things I do is I make sure that if I give you something, I can back it up. Y'all know I don't just go around throwing stuff out, and I don't just get behind anybody. That's like Dexter Taylor up in New York. I have Dexter Taylor. We get Dexter calling in from prison every Sunday night. We didn't do it this Sunday because I wasn't feeling good. But usually on Sundays, we have Dexter Taylor calling in from prison because that's another black man that has been railroaded by the system. In his case, it was Democrats. It was black Democrats who railroaded this black man because of firearms. Justice. That's all I've ever said. I never said do something different or do this here for justice. The justice system is broke. It's always been broke. It's always been one-sided, and nobody wants to fix it. And the only way we can show you is give you people like Philip Vance, who is sitting in prison right now in Rush City, Minnesota, behind bars for a crime he did not commit. So, Miss Nicole there, that's who you was listening to, is basically the lead on this thing to get him out of prison, talking to him, making sure people, his case, his story comes to light. I'm gonna get her on here, and we're gonna do a little special. We'll talk about. Well, I had her on here before a while back, talking about Philip, talking about him being behind bars. Only thing we ask is for people to look into his case and come up with a fair conclusion. If you look at his case and say, no, he should be back there, then that's cool. But if you look at his case and you say, this man was railroaded at a young age, the cops did him wrong. The cops did him very wrong. Just like the other two who got out. It's time for Philip Vance to be released. No ifs, no ands, no buts. And as long as he stays behind bars, justice will not and has not been served. Period. Point blank. Period. Point blank. I'll be talking about this a little more tonight. I will be on tonight at 7. So if you're not doing anything, you want to hang out with me, come and hang out. Again, like I always tell people, if you want to have a conversation, you can always come on there, hang out. We can have that conversation. No ifs, ands, or buts on that. But again, that's what today was about. This is a man who's been in prison. Philip Vance has been in prison for 22 years. Kathy Keenum was the prosecutor on this here case. He was railroaded by the police department, by a gang force that were in 2009. The FBI came in and totally disbanded this here gang force because they was so corrupt. He got caught up in the things that they done. There is new evidence that they're asking the courts to look at. That's what today was about, because there is new evidence out there saying that this was not the guy who murdered. There's people that they paid money. Listen to me. There's people that they paid money to lie on this man. The Kathy Keenum and her ilk paid money to lie on this man. And those people that they paid money to recanted their story and like, you know what? I can't do this anymore. I lied on the stand. They paid me to say these things. Not only that, they had some people who didn't even know of the story. Listen to me. That the police officers told them what to say, and they said it. This is the justice system. This is the justice system that we have to deal with as black people. And it's the same justice system from the time that they freed us as slaves. The same justice system. And this is what we go through. They lie on us, and they find ways to put us behind bars. And then once they get us behind bars, they use those cases to move up the ladder. Amy Klobuchar did it. Kathy Keenum has done it. White women. And what's the history with white women and black men? Well, think about the history for a second. Think about the history for a second. Come on now. Emmett Till. They have used black men to get themselves up the ladder. Amy Klobuchar did it. Kathy Keenum did it. And the only thing we're asking for right now is justice. That's it. That's it. No, I ain't asking for nothing special. Justice. And I don't understand why that's so hard for people to understand. Why you have to fight a group of people for justice. All right, fam. That's it for me. Like I said, I will more than likely. You know what? I gotta go on a show here pretty soon. But if you want to catch up on here, what happened today, you can go on my YouTube channel. Check me out, right? Check me out. You can go on my YouTube channel. It will be on there in a little bit here, and you can catch up with what Nicole was saying and things of that sort. And she is relentless. She is one of the people who turned me on to Marvin Haynes and Myron Burrell. She was behind both of those. Now, like I said, she was with Philip Vance and the whole nine. So whatever I can do to get this young man out of prison, I'm going to do it. Whoever I can talk to, I've made phone calls. I've talked to a couple of people to see what we can do. We just need some people who are willing to run off at the mouth, get out there, get his name out there, and see if we can't get him out. But again, if you missed anything, go to my YouTube page, subscribe for me. Just hit it so when I do come on, you get a bell. If you want to know how you get there, you can get there by going to @TimmyChristopher /J8T @TimmyChristopher -J8T. All right. Anyway, hey, I'm out, fam. I'll see you guys later on tonight, and be good until then. Peace.